G'day everyone. This is the second video in week 2 of our admin law course. In the first video we looked at certiorari, the ancient writ by which a higher authority reviews the decisions of a lesser authority. In this second video we're staying back in the past and we're looking at two more writs, Mandamus and Prohibition. Remember that a writ started out as a written command from the king. So, Mandamus and Prohibition. We're going to start with Mandamus. Mandamus comes from the Latin word mandatum, which means to command. There are a number of English words with the same Latin root that you'll be more familiar with. When something is mandatory, you've been commanded to do it, and there are no options. The word command itself contains the echoes of mandatum. If you give someone the power to issue commands, you give them a mandate. When someone is held in prison by the court's command, they are on remand. And so you can see that while mandamus might look like Latin gobbledygook, it makes sense as a word and it gives us clues about what mandamus might do. You see, a writ of mandamus says to someone with a duty, you must go and perform your duty. So back in the early centuries of the common law, as we've already discussed, the king and the central government relied on lower level officials on the ground to actually get things done. But what if those officials just decided to kick back and do nothing? Well, in that case, someone who wanted those duties performed could go to the central government and seek a writ of mandamus. It was like a way of saying, hey, this local official is not doing their job. You're the king, can't you make him? If the king agreed, then a writ of mandamus would go out directly instructing the non-performing official to do their job. And ignoring a writ of mandamus, as you could imagine, would have had even more serious consequences. Let's look at an early example called Curtis's case, which is nearly 800 years old. Now, one of the most important things which early English law spent a lot of time worrying about was title to land. When King William the Conqueror first set up his system of nobles, he gave each of them control over land. Land produced rents and was probably the most valuable thing in the whole kingdom. Disputes about who owns land and what the boundaries are and how the interests of landholders could be protected, well, they were a very significant feature of those early cases. If someone died without an heir back then, the land would go back to the crown and the king would give it to someone else to control. All of this was organised by a person with the odd title of escheator. So the escheator would identify the land and anyone with an interest in the land and would work out what would happen with it next, all on behalf of the king. Curtis was a tenant of part of the land when the owner died without an heir. The escheator, however, took no notice of his tenancy. Curtis didn't want to lose his home, so he went to court and obtained a writ of milius inquirendum, which required the escheator to examine his claim in relation to his tenancy. The escheator didn't respond to this duty, and so Curtis went straight back to court and obtained a writ of mandamus, under which the escheator was specifically commanded to do his duty. The history books don't tell us whether Curtis ended up with his land or not, but I really hope he did. Do you see how it works? Mandamus was an instruction from the central government to a local official saying, you have a duty, go and do it. Another example I can give you is from a case called Kissen Perry, a case about a squatter whose land was being resumed near Sydney so that the government could build a public school. When he went to court, what he actually asked for was a writ of mandamus instructing the Department of Public Instruction, which nowadays we'd call the Department of Education, to assess his land value and pay him compensation. So the court said to the public servants, you have a duty, go and do it. Mandamus does have one limitation. Before you could get a court command to do a particular duty, you had to be able to prove that the duty as such existed. So the court didn't have some sort of general right to just issue mandamus and order public servants to do things. For instance, if the public servant had a discretion about whether or not to take some step, well, mandamus couldn't help. There had to be an actual duty, a responsibility to act. Because if there was no duty, well, how could a duty be enforced? Prohibition, as you can probably guess, is the exact opposite of mandamus. So where mandamus says to the public servant, you must do this, prohibition says, stop everything, you must not do this. It can be used to prevent a public servant or an official from going ahead and implementing an unfair decision. To see this in action, let's go back and have a look at a really old family law case called Langdale's case. It's a case from 1572, so it was happening around the time William Shakespeare was a child. When Marmaduke Langdale married his wife Joan, and yes, seriously, his parents named him Marmaduke, then in accordance with the usual law back then, he took control of all her possessions. She ceased to be a legal person and became a kind of wholly owned subsidiary of her husband. This was a legal doctrine called coverture, and it lasted until the 19th century. Women literally ceased to be people when they were married. Eventually, there was trouble in paradise in the Langdale household, and Marmaduke set his wife aside. Back in those days, divorce was next to impossible, but it was very common for people who were reasonably wealthy to effectively end marriages by simply sending their wife away and pretending she no longer existed. However, they were not allowed to simply abandon their responsibilities to their wife, and so it was possible for the wife to sue for maintenance. And that's exactly what Joan Langdale did. She sued in the ecclesiastical court, so the church court, by bringing her case before the Bishop of Canterbury. This would have seemed like the logical thing to do because marriage back then was a church matter, not a civil matter. So it would have made sense for the church to also make decisions about maintenance. The last thing Marmaduke wanted, though, was to find himself standing in front of the bishop to explain why he had set his wife aside. Given the church's attitude to the sanctity of marriage, that was not going to go well for him. And so he countersued, but he sued in a common law court. The first thing he asked was that the common law court take steps to prevent the church court from issuing a judgment. The common law court agreed with Marmaduke that they were the correct court, and so they issued a writ of prohibition, prohibiting the church court from ruling on the case. You see how it works? The central authority, the Crown Court, gave an order to the church court saying, you must not proceed. History doesn't record what maintenance Mrs. Marmaduke eventually received, but you can bet it was less generous than what she'd have received from the church court. A more modern example, an example from Queensland, comes in the Attorney General of Queensland against Wilkinson, a 1958 case. Back in those days, the idea of Sunday trading was very controversial. The Christian tradition, of course, was that Sunday was the Sabbath and that nobody should work on Sunday, but instead they should go to church. Church in 1950s Queensland was a big deal. 88% of Queenslanders identified as Christian, and the numbers of church attendance and Sunday school attendance were growing. So a decision to allow Sunday trading was not just a commercial decision, it had significant social and cultural impact. From this perspective, petrol stations were crucial. The 1950s was the decade when motor vehicle use in Australia took off, and cars went from being a luxury item to being a commonplace means of transport. The F.J. Holden, released in 1953, was a big contributor. Now, the concern was that if petrol stations were open on Sundays, then families would choose to travel on Sundays instead of attending church. Service station owners, of course, hoped that that was the case. They went to the Industrial Court of Queensland and sought permission for limited Sunday trading. And they won, because the Industrial Court focused only on the trading aspects of the decision. The decision of the Industrial Court was challenged in the Queensland Supreme Court and then the High Court. The decision of those courts was that the Industrial Court had gone beyond its powers, beyond its jurisdiction, by making that decision, and as a result, a writ of prohibition was issued to prevent the decision from going ahead. See how it worked? The higher authority decided the decision was not proper because the Industrial Court had gone beyond its powers, and so it issued a writ of prohibition to prevent them from going ahead and implementing the decision. Incidentally, Sunday trading remained contentious in Queensland well into the 2000s, and to this day, Sunday trading hours are more restricted than on other days. These days, however, that's mostly a matter of penalty rates and workers' conditions, given the massive decline in church attendance. So now we know about the writ of certiorari, under which a court called for a decision to come before it for review. And we know that after such a review, the court might have issued a writ of mandamus, telling the lower authority to carry out a particular duty. Or they might have issued a writ of prohibition, telling the lower authority that they must not carry out certain activities. In the next video, we're going to learn about the final two sorts of writ that we'll discuss in this course, the writ of habeas corpus and the writ of quo warranto.